We have the advantage of being today with Damien
Geradin, yes,
who is the partner of Legal. And he is a great expert in the relationship between competition and arbitration. And would like to take advantage of that opportunity to ask him about that relationship, how he figures out that relationship.
Sure. So, arbitration and competition law are two very interesting subjects by themselves, and they increasingly interact because arbitration is everywhere now. It's a growing subject, but this is also true of competition law. So, the circumstances in which you may have competition law, questions arising in arbitration are becoming more frequent. And so the first question is whether competition law rules are arbitrable. And the answer is yes. In the European Union, the Court of Justice has made clear that arbitration rules can be arbitrable. And so it's perfectly okay for arbitrators to deal with competition law issues when they arise. And they very often arise in the context of contractual disputes, where one party has not, complied with its obligations on the contract, and then the other party will start arbitration. And then, as a defense, the party which has not complied with the contract will say, "Oh, anyway, this contract is null and void because it breaches competition rules." And then, of course, the arbitrators can look into the matter, and they will either decide that indeed it's incompatible with competition rules or it's compatible with competition rules. And then the question that I will especially address in my presentation today is the extent to which domestic courts, when they review arbitral awards, they can have another look at competition rules on the ground that by breaching competition rules, the award would actually breach public policy. And there are different schools of thoughts. There is the minimalist school of thought, which says no, arbitral awards are final. So, to the extent there is a review of the arbitral award, it should be really minimal. You should only look at flagrant mistakes, big mistakes. But there is another school of thought, which is called the maximalist, where people say no, not at all. In order to make sure that competition law is effectively applied, you need to do a more in-depth review of the arbitral award. So that's basically, these are two critically important questions: arbitrability, but also the extent to which competition rules are of public policy, and if that is the case, what should be the judicial review or the standard of review.
What's your opinion?
Well, it's an opinion that is not always shared by arbitrators, because, of course, experts of arbitration law, they're really keen on the finality of the award, and so they tend to be minimalist. But as a competition lawyer, I think that a minimalist standard of review is not necessarily ideal. And in a recent opinion, Advocate General Watley basically said that a minimal standard of review, such as the one that is practiced by French courts in a case called Genentech, was not actually satisfactory because it did not ensure the effectiveness of EU law. So, of course, it's an opinion. The Court of Justice may decide something different, but to some extent, I think it gives a little bit more credibility to the maximalist position. And of course, this case has raised a lot of debates between arbitration lawyers and competition lawyers, and I'm sure that it will lead to a very interesting discussion today.
Don't you think that these maximalist thesis will open the door to a real review of the awards instead of pure execution?
Yes, and I think that you should look at it in a pragmatic manner. Of course, we don't want the domestic courts to redo completely the analysis. If the arbitrators have done a perfectly fine analysis and they've looked at the facts and the law and they come to the conclusion that, after this serious analysis, they come to the conclusion that competition rules have, for example, not been violated, there's no point to do it again. By contrast, there might be situations where the arbitrators didn't do a good job. They did a very superficial analysis or they didn't do any analysis. And in that case, I think there are more arguments to do a more serious analysis or serious review by the domestic court.
The point is that we are not focusing on competition law in relationship with arbitration, but there are many other laws involved in arbitration. Why we should give this special treat to competition laws instead to other?
It's true. It's true, and I don't think there should be any special treatment. But I think that the rationale that is sort of followed by the Court of Justice is to say that competition rules are a fundamental aspect of the EU treaty because it's there to protect the internal market, which is basically what the European Union is about in economic terms. So competition rules may have a particularly high status when it comes to EU matters, which may not be true of other rules. So we will see what the Court of Justice will say about other rules, but at least for now they seem to consider that a serious review of competition rules should be done by the reviewing court.
And we are talking about international arbitration, and when we talk about competition rules and arbitration in a domestic case, what's your opinion? Do you think that for instance, the case in Spain, the Tribunal Superior de Justicia should review the rightness of the award based on the application of our own competition rules, using the public policy and economic public policy as a justification for?
Well, I think it's a little bit different because, of course, if you apply your own competition law, then I think that...
Which is always a development of the
European one. Yeah, absolutely. But I think then there's maybe less of an argument for a sort of more extensive review. I think that EU competition law, as I said, has this sort of special status in the treaty, where Spanish competition law is just a law like another one. Now, of course, what happens very often is that in cases, the European competition law and the Spanish competition law are applied together. So one has to see, but if it's a purely domestic case involving only Spanish competition law, then I don't think that the Court of Justice case law is so relevant.
Talking about competition law, do you think that really the Commission is understanding the challenge that the new technology, the new business models are imposing to the way competition law should be understood?
It's a very good question, and it's a subject of a lot of debate, because some people say that if you look at the